Good afternoon. I received an uneasy task of being the last, but I hope we'll make it till the end. Fortunately, my topic concerns something that really doesn't concern us at first sight. The topic is the relationship between the ICC and Central Europe. And since none of the cases before the ICC dealt with the Central European countries, therefore the question why we should care is really in place. Therefore, I decided to research first the implementation stories of the chosen countries. I've decided to research the V4 countries since I assumed that for most of us it's maybe the closest to our hearts. And later on, I will deal with how the core crimes of the Rome Statute were implemented and enhanced in the criminal codes of these countries. First, I will start with Hungary. Hungary sees the relationship between the international law and the domestic law as a dualistic model. Its implementation procedures uses a separate transformation. And the last part of the transformation is the promulgation from the president. And now we come across the issue, which is quite current in relation to the Rome Statute, sadly still current. In 1999, Hungary was, the representatives of Hungary were part of the Rome Conference. Its representatives signed the treaty. Later on, it was ratified by the parliament, and it gained force in 2002. However, the promulgation from the Hungarian president is still missing, which means that the domestic law of Hungary did not fully implement the treaty until today. There were no official statements, however, there were certain signs which prove, which can we deduce that from some discussions as well as some scholarly works. And this presents us that the reason why the president omitted to do so is related to the immunity clause and the concerns. Just a fast remark, I found this fear as unfounded, since even the Hungarian constitution, as the other constitutions that I will mention as well, has the possibility to impeach the president. And there is very unlikely that the actions of the presidents, the previous actions, would be unknown for the public if he committed such hideous crimes. We may move further to the Slovak Republic. The issue was easier. The ratification was achieved in 2002. Since that year, the Rome Statute is legally binding. The Slovak constitution stipulates a precedence when a treaty is directly establishing the rights and obligations of natural persons, which means that if there is a collision, the international law is taking precedence over national law, and the question regarding the immunities were avoided. Therefore, in Slovak Republic, the Rome Statute is unproblematic. The Czech Republic is somewhere in between. The signing of the statute was easily achieved. The representatives were active on the Rome Conference. However, further, the parliament decided not to approve the treaty, and the reasons were based on their argumentation that the Rome Statute is not in accordance with the Czech constitutional order, which means the constitution and the Czech Charter of Fundamental Rights. The real reason behind that was, again, the immunity clause. However, later on, the Czech Republic wanted to accede to the EU, and it had to amend the constitution, and it resulted in an amendment which stipulates that the parliament can give some rights to an international organizations by an international treaty, and since then, there were no barriers for the Rome Statute as well, and this resulted in the 2008 agreement for the parliament, and then the signature from the president as well. However, this means that the Czech Republic was the last country of the European Union which ratified the Rome Statute. In Poland, the government in 1999 signed the treaty. In 2001, it was ratified. There was just one notification under Article 87, which meant that the documents, the cooperation, will be done in the Polish language. As regards to the Constitution of Poland, in Article 91, it stipulates that after the publication in the Journal of Laws, this international treaty, the Rome Statute, gains direct effect. So let's move on to the implementation of the core crimes into the criminal codes of each of these countries. In Article 142, the genocide, the crime of genocide, is in the Hungarian Criminal Code. All the elements which you can see in the Rome Statute are the same. The sanction stems from 10 to 20 years or life imprisonment. In case of Slovakia, Article 418 stipulates again, similarly as the Rome Statute, all the elements of the crime. The sanction stems from 15 to 20 years. And in a second subsection, there is the mention of the aggravated form in connection in the situation of an armed conflict where there is the possibility of the life imprisonment as well. As regarding the Czech Republic, again, similarly to the other previous ones, genocide has all the same elements. The sanction stems from 12 to 20 years or life imprisonment, in the wording of the Czech Criminal Code, exceptional punishment. As regards to Poland, the crime itself is divided into 3 subsections. You can see that I highlighted something which I found interesting, and I couldn't see it in the previous criminal codes. There is an additional element, ethnic, racial, political, or religious group, but an additional group with a different perspective on life, which I found as something that is broadening maybe the scope of the crime of genocide, and I found it maybe useful. We may move further to the crimes against humanity. In Hungary, you can see this crime enhanced in Article 143. All the elements, the policy requirement, as in the Rome Statute, are similar. The sanction stems from 10 to 20 years or life imprisonment. In the case of Slovakia, the name of the crime is inhumanity or cruelty. The elements are again the same, and the sanction is from 12 to 25 years or life imprisonment. In Czech Republic, the crimes against humanity are called as attacks against humanity. The elements are similar as in the Rome Statute. You can see in genocide as well as in crimes against humanity that the criminal code is quite the same as in Slovakia, and the sanction is from 12 to 20 years up to life imprisonment. As regards to crimes against humanity in Poland, the Article 118A was added in conformity with the ICC requirement, with the Rome Statute in 2010. I highlighted some parts which show that the Rome Statute is referring quite directly. You can see that all the elements are the same as the Rome Statute. However, I highlighted also a part in subsection 2, in the method of deprivation of liberty. I found quite interesting there is an additional requirement with a period longer than 7 days or with particular anxiety, as well as in paragraph number 5, you can see forced pregnancy with an additional requirement of intention of influencing the ethnic composition of the population. Both these additional elements or requirements I found as somehow narrowing the scope of crimes against humanity in the Polish Criminal Code, Codex Karny. The war crimes were quite well elaborated yesterday by Professor Varga. I don't want to go into details. However, you can see that 12 war crimes are in the Hungarian Criminal Code. I think the Rome Statute is quite comprehensively introduced or enhanced in the Criminal Code of Hungary. But what I found interesting is how war crimes are in Slovakia, even though that each of the crimes which are in the Article 8 of Rome Statute are not explicitly stipulated in the Criminal Code of Slovakia. I found Article 433 called War Injustice as something interesting how Slovakia decided to solve the issue. The legislator decided that it directly refers to the Rome Statute, and that even though there is no explicit prohibition of certain crime which is in the Rome Statute, in the Slovak legislation, under the domestic legal order it will be punished, and I think it with one sentence solved the whole implementation of war crimes into the legal system of Slovakia. As regards to Czech Republic, you can see that these war crimes are maybe a little bit shorter, although in some of the articles you can see in the subsections that many of the crimes in the Article 8 of the Rome Statute are enhanced in those parts of the criminal code. As regards to Poland, I found interesting mainly the Article 120 and 121, which both refer to the means of mass extermination. In the situation of 125, the management, the manipulation, the selling, and the whole trading with means of mass extermination is prohibited, which I couldn't see in the previous legal frameworks. I would like to move to the last core crimes. However, I need to start with Slovakia, since the Kampala Amendment, the crime of aggression, wasn't ratified in Hungary. Therefore, I cannot deal with that. I will start with Slovakia in Article 417, called Endangering Peace. It's divided into two subsections. In the second subsection, you can see an aggravated form in connection with a foreign power as a member of dangerous group or during crisis situation. Czech Republic added, in conformity with the Kampala Amendment, Article 405, called Aggression. I found it as a nice article which directly refers to the provisions of international law and the Charter of the United Nations. In Article 406, it directly prohibits the incitement of war and the preparation of war in Article 407. Therefore, in my research, I found this maybe as the most comprehensive way how to implement the crime of aggression into the domestic legal order. Poland, Article 117, divided the crime of aggression into three subsections: preparation, the waging, and public incitement. And I would like to conclude. As you can see, the implementation procedures in many of these countries were problematic, and for example, in Hungary, it's still problematic until today. The core crimes are part in all of the criminal codes. The genocide and crimes against humanity have the same wording in all of these countries as it is in the Rome Statute. The sanctions stem from 5 years of imprisonment to life imprisonment. However, as related to the war crimes, you can see some differences. Maybe the most elaborated is the Hungarian. However, definitely interesting solution you could see in the supplementary provision in Slovakia. As regards to the crime of aggression, you could see that there are different wordings in each of these countries. And from 1 year, the sanctions stem from 1 year to life imprisonment. As an interesting remark, which I found during my research, is a case from Germany. In January this year, there has been a case filed against Myanmar high-ranking representatives for committing war crimes, crimes against humanity, and genocide. The case was filed on the basis of universal jurisdiction in Germany. The whole case is trying to rest upon the act, which is the result of the implementation procedure of the Rome Statute in Germany. This gives, I think, an interesting thought, although it opens the Pandora's box, that even though Central European countries are not this directly affected, there is a way of the operational scope how to fight impunity even in regions which are not directly are not our regions. And overall, I think that even though the ICC is in our region more like a preventative or a warning measure, however, the Rome Statute, its establishing document, is the one which had huge effect on the development and the harmonization of the criminal justice in our region. Thank you.